This is the zoning board meeting of June 10. We have present Linda Munn and Orrin Glick and myself, 3 people. That's a quorum, so we will be proceeding. We'll be following the agenda, which is at the Southampton Village Agenda Center. And the first case is, and Lisa, are you all set to go as well? Yeah. Thank you very much. And we have Lisa Rickmers as well, who is our environmental consultant. Thank you. So we'll start with case number 31, the first case 3190, Maximilian. The applicant has requested an adjournment to July 3rd. Do I hear a motion to adjourn that case? A motion. Second? Everyone in favor? Aye? Aye. And that case is adjourned. So our next case is the Eiffel Residence case. It's case number 3199, 2020 Meadow Lane. If folks want to come forward and let's chat about that case. Yeah. Thank you.
Tony Pascal, attorney, and CMX Sammy, architect.
Great, thank you so much.
Okay, so we had done a full presentation the last time, and I don't want to speak for the board, but we got generally positive feedback with one request that was conveyed back to our clients, and that was to try to add some buffer plantings to increase the amount of native plantings. And so because our application is for a Dolliver line dune setback, we focused on the dune side to create a buffer between the house and the small lawn that's now going to be left and the dune itself. A plan was submitted. It includes removal of lawn and some non-native plantings, and then revegetation of 2,370 square feet of...
Can I ask you to hold one second?
Sure.
Is there any way we can get this up on the TV?
He's going to try. CMAC's going to try.
It's on the one to the left. This one's not.
Oh, sorry. Okay.
There it is.
I didn't see the one to the left.
Yep, it's up there.
I will sneak a peek at you as well. Thank you. We're all set.
So with that diagram, there's 2 shaded areas. One is the lawn that's being removed, and the other are non-native plantings that are being removed. And both of those sections are going to be replaced with the 2,370 square feet of native plantings. And the native plantings were selected by Inner Science based off of the town's native planting list, because the village doesn't have its own list, and we understood uses the town's list. So in addition to that, some of the junipers that were in the area, which are non-native, are being removed, but they're going to be kept as screening for the sides. So you can see those on the plan as well. So it's really more for privacy screening between the neighbors and our client, but they're healthy, and so the choice was made to save those trees.
All right.
Okay?
So you're going forward with the revegetation concept plans, the proposed planting buffer, as well as the moving those junipers and so on and so forth to be simply screening between neighbors as opposed to down toward that beach area.
Exactly, yes.
All right. Sounds great. It does. Any other comments on your part? No?
Oh, no.
It sounds
no.
like exactly what we had asked for.
Yes,
Thank you.
that was the idea. It was, and it was well received and by the clients, and so they were happy to come up with this plan.
Well, we appreciate their patience. If that's everything, I'm going to ask the board to deliberate at this point.
Sure.
Everyone, what are your thoughts, comments on?
Before you do, see if anyone else in the audience wants to be heard.
Is there anyone else present here who'd like to make a comment on this public hearing for 2020 Meadow Lane? No? Is there anyone on Zoom who would like to make a comment on 2020 Meadow Lane's application? No? All right. With that, we'll move on to deliberations amongst the board members. Any thoughts or comments on where we are at this point with this particular application?
I think they addressed all of our concerns, and they've done exactly what we asked, and I think it's great. I think it's going to be great improvement.
Right. Okay. So thank you very much. At this point, Brian,
Yes.
Can we go to vote, or do we need to take an indication and come back next time?
So what you should do is move to close the hearing.
Yeah, and then vote.
And then either vote on the application or request that a decision be provided so that the board can approve that at the next meeting, at the June 26th.
What is the difference between going ahead and voting now versus voting in the next meeting with the decision?
Timing for a challenge if somebody's not satisfied with the result and you don't have the findings filed.
Excuse me?
The decision includes the findings. That you know, your decision and the underlying findings and the conditions.
Oh.
So there's a certain time frame from which an appeal of your determination runs, and if in fact you make the determination tonight orally but not with that paper,
Yeah.
someone who may want to challenge may not timely file, may run into
Clock
it.
starts to run. in other
Exactly.
words. Okay, but assuming that hypothetically, if we are going to be approving it, they're not going to be challenging it, so they're not damaged by the clock starting to run.
That's why I said it that way.
I see, okay. It appears that people are inclined to be approving this, so I suggest we go ahead and close the hearing and we go to vote so that the opinion can be prepared and you can go forward more quickly with your activities.
Much appreciated,
Okay.
if that's the
Is that okay with
case.
everyone? All right. Do I hear a motion to close this hearing?
I motion.
Second? All those in favor say aye. Aye?
Aye.
And I think that'll do it. Thank you very much.
Okay.
We
Thanks,
appreciate
Judy.
it. So Brian will prepare that opinion and we
Well,
will.
I thought you were going to move tonight to approve.
Oh,
Is that
sorry.
what you're doing?
Sorry, that was
Move
just
to
the closing.
approve.
That was just the closing of the hearing. I would like to now suggest that do we have a motion to go ahead and vote on this
Yes.
matter? Yes. Do we second?
Yes.
In favor of it.
All those in favor of
Okay.
approving this application?
Yes.
Aye.
Aye.
All those against is no, because it was unanimous, and so with that, it is approved.
Thanks so much.
So I'll have
It's been a
the
long road.
Right, I'll have the findings and the decision for the next meeting.
All right, great.
Okay.
Thank you
Thank
so
you.
much, I appreciate it. Okay. So we go on to that is the second wetlands environmental case. The third is the Meadowmere Partners matter. And that is a wetlands permit. The opinion has been prepared, the permit has been prepared by Lisa. Is anyone here from the applicant? I don't know that they are.
InterScience
Here we
is
go.
here.
There we go. Yeah, here he is. A familiar face.
Jim Walker from InterScience.
Yes.
I think we've submitted everything that we needed to, so I'm here to answer any questions.
I personally don't have any questions of you. Do you all have any further questions about this matter? No?
Seems pretty straightforward.
Yeah, it seems very straightforward. I think we need to get the drainage ditch cleared. We're in the same situation. Do we need any reports? Well, we have a permit from you, correct?
Yes, so you have a permit that's been prepared, and I'm viewing it as a continuation of the previous permit.
Exactly.
So I'm viewing that as a type 2 action under seeker, requiring no separate seeker review, unlike most wetlands permits. The application accepts this as being in conformance with the wetland special permit guidelines in the code, and has the standard kind of conditions that the work will be done in accordance with plans and permits will be maintained and renewed as needed from other agencies as well, such as the DEC. And I think that I believe the one we have in file from the freeholders maybe needs renewal. But if I have to look,
But you've prepared a wetland special permit.
the wetland special permit. So I'm just saying that the conditions at the end of the wetland special permit are the standard
Oh.
conditions about maintaining and being in compliance with any other permits required from other agencies, as well as with the plans that are provided, and as well as the annual reports to report on progress.
Yep.
The only permit is the DEC, and it's still valid.
Yeah, sorry, I was getting this
I think
confused
she's
with the.
confusing the.
Yeah, sorry, I
the
have two
the
permits
dock,
on tonight. You're right. The dock was the one I was confusing.
Which is later on.
Later on.
And special condition 3 is the project shall continue to comply with all conditions outlined in wetland special permit 3089.
Yeah, well, that's fine.
That would not be.
That was the original wetland,
the
special
original,
wetlands permit.
Right, okay, all right. So with that, thank you. So we need to vote on, so are there any other comments from you all regarding this application?
No.
All right. Is there anyone in the audience who would like to comment on this application? Is there anyone on Zoom that would like to comment on the application? All right, we'll move to deliberations. What do you all think? I think it's very straightforward. I'm inclined to approve. I would say that, all right.
Approve it.
I'd like to make, do I hear a motion to close this particular matter so we can go vote?
I motion.
Second? All those in favor of closing it? Aye?
Aye.
All right. All those, do I hear a motion to vote on this wetlands permit application?
I motion to vote.
Second? All those in favor of approving the wetlands permit? Aye.
Aye.
It's approved.
Thank you.
Thank you very much. All right. And that is 66 Meadowmere. So now we move on to the new cases. Meadow Club number 3204 was to be a new case, but the applicant has requested an adjournment. Do I hear a motion to adjourn this case as they request to June 26?
A motion
Second? All those in favor? Aye?
adjourned.
All right. So the Meadow Club matter, case number 3204, is adjourned. And that takes us to area variances. And the first carryover case is 3186 Matthew and Ashley Cordell, 39 Moses Lane.
For
Mr.
the applicant, John Bennett, and members of the family are here this evening. I just want to make sure that we have the rules of the game understood. My understanding is, and this is out of counsel's mouth, so I would like an affirmative for the reporter to take down. What has been said is, in the absence of a unanimous vote, either way, this evening, that would be a non-vote, and the matter would be carried over to the next meeting?
Since we have 3 board members, we need all 3 to be in favor of a particular motion, and if you don't have 3 in favor of a particular motion, it's a non-vote.
Okay.
And if that happens to be the deliberation in which you don't have the 3 votes, that will get carried over for further discussions at the next meeting.
At the next meeting? Only if there were a unanimous denial would it be a denial, and then, of course, we would have our remedy.
The same in either direction, correct. We need 3 in either direction, whether it's a vote to deny or a vote to approve, you still need 3 members to vote in that, for that motion.
Okay, so with that understanding, we will proceed.
All right.
Okay, thank you.
Thank you.
Thank you. Thank you.
So-
And thank you for the explanation. I appreciate it.
So at the last meeting, we heard information that was presented from you and documents, which were great. Thank you very much. To
Hopefully you got the
supplement-
transcript, which
Yeah.
I made sure. Okay,
Sure.
good. Thank you.
And it supplemented the previous documentation, so we have information from you.
Mhm.
Is there anything that's come up between then and now that you'd like to share before we go into our own deliberations?
Well, we did supply also yet another broker affidavit as to the economic damage from Molly Ferrer. Or actually, her name is Mary Ferrer, but she's known as Molly. And I don't know, is there anything, I think we pretty much going to, I think had a very exhaustive record that we've submitted.
You have.
So that's fine if you guys want to.
And I want to rest assure you, we've received everything, and we've read everything, and we will be talking about it, and I appreciate your patience. I know this has been a long road. All right, so as residents, we appreciate your patience. Thank you very much, John. Is there anyone who's here present today that would like to make additional comments on this particular application? None? Is there anyone on Zoom who'd like to make comments on the particular application for 39 Moses? No? None? I'm hearing Stacey and shaking. All right, so let's go ahead and deliberate amongst ourselves. I'll just kick this off, I thought, just to start it going with a comment. And that is, Mr. Bennett submitted a document dated May 8th, 2025. And on page 3 of that particular document, I'll just kind of paraphrase it for you all so you have a quick, easy reference.
Okay.
New York State Real Property Actions and Procedures, Section 1951 is cited. And Section 1951 explicitly says that a covenant, which is what we have here on their property, a covenant can be extinguished if there's been a change in circumstances. So that seems to be the covenant test that caught my attention. And then he cites some case law. And basically, if the purpose of the restriction has already been accomplished in another way, or if there's been a change in conditions, then you no longer need, such that you no longer need the covenant, then you can extinguish the covenant. Now, in my view, that makes all the other deliberations on the 5 factors and all that sort of thing less important. The issue here is I have a covenant. I have to decide if I can extinguish the covenant, and the standard now is it can be extinguished if there's a change in circumstances that satisfies me that the goal has been accomplished.
What kind of change in circumstance would qualify?
We have to decide that, and I would suggest that here there have been so many zoning rules passed that they are now circumscribed in what they can build, unlike what was happening in 1998. They have height restrictions, they have pyramid laws, they have all these things now that are going to hem in the construction just as it would with everyone else. So I think the need to isolate and identify this particular property with a restriction, with a covenant, is no longer needed. I think that the zoning rules do that, and we have faith in our zoning laws. Now, I will say one thing before I hush up and let you all talk. The difference here, though, is this is a flag lot. And in a flag lot, you are surrounded by your neighbors. So the bigger you build, the more ostentatious it is for your neighbors that are literally peering into the four walls of your house, if you will. Having said that, there are other flag lots in the village, and they're all subject to the change in circumstance of the zoning laws. So I don't view that as a distinguishing factor that would change my view. So that's kind of where I ended up. I just thought I'd reason through that with you. I think the covenant is no longer needed, and I think Section 1951 gives us the path forward. But what do you think?
I think you just made a very, very concrete, rational
Yeah, I think
argument.
covenant needs to be done away with. I mean, it's just, I think this is reasonable.
Okay,
I think what's going on here is reasonable.
okay.
And, you know, it's-
Are
I mean,
we,
I honestly don't like the fact that it's going to be a two-story structure in this tiny little lot, surrounded by everybody else. But you make an argument,
the code is spoken.
Code is spoken. That's right.
code is right,
If somebody doesn't like it, they need to change the code.
right, exactly,
Yeah,
exactly.
that's the way I feel. And singling out one lot kind of bothers me in
Yeah,
that
me too.
sense.
Agreed.
Right?
Yeah.
All right. Are we comfortable enough to either A, make an indication as to which way we'd like to vote so that Brian could prepare an opinion for the next meeting? Or would you actually like to close this hearing once again and go to vote if you're comfortable with doing that? Which way would we like to go? Indication or actual vote?
Let's vote.
Vote.
Let's vote?
Vote.
All right. Do I hear a motion to close this hearing?
I motion.
Second? All those in favor of closing the hearing?
Aye.
Aye.
Do I hear a motion to send this to a vote? Yes,
Motion
second?
to
Oh,
vote.
what do you mean send it to?
Well, I mean, do we have to move
So-
to vote?
No, you don't have to move to vote.
All right.
You're at that point where you can, anybody can make a
Okay.
motion to approve. If you are going to be making a motion to approve, I would suggest, number one, that you determine that this is a type 2 action under secret. Number two, that you're approving the application as requested. And number three, although it wasn't identified in the application document specifically, you also would be agreeing to take whatever steps are necessary to effectuate a formal modification or extinguishment of the covenant as it is recorded with the county clerk's office.
All right. Can you give me those again? Because we do
I-
have to vote on each of those right now then,
Yes.
correct?
So one is just that it's a type 2 action under secret, requires no further environmental review. Two is a motion to, or within the same motion to approve the application for the variances that have been requested. And three would be to approve any necessary documents that would be needed to extinguish the covenant that is recorded with the county clerk's office.
So are we,
So the relief requested, use the word relief instead of variances.
okay. The third one, we have to approve, we're not going to be reviewing the covenant extinguishment, correct?
So the covenant provides that it can only be modified, rescinded, extinguished by action of the Board of Appeals. So you would have to take action, in addition to approving the relief requested, for the covenant to be removed from the property to then permit this to move forward with the building department. You would have to take action to formally agree to rescind or extinguish the covenant. What'll happen is the applicant will submit a document providing for that extinguishment, and you would then sign it if you've been authorized by your board to sign, which is
Right,
what
but
you're
that's-
what you'd be doing is authorizing the subsequent execution. You don't have to do anything. Mr. Bennett will be
Right.
handling it and sending it to us for review, and we'll give it to you, and if it's in order, send it to you for signature based on the decision you make tonight.
Correct, but we are not actually voting on that third step. That is simply a step that will occur once we approve the extinguishment of the covenant, then he would come forward later with the documentation to do just that, and we would approve that, correct?
The relief requested is to remove the condition that the board imposed whenever this condition was imposed. There's a second necessary part to that, and that is that the covenant be rescinded or extinguished, with either term is acceptable. So you would have to take that step, which is why I'm suggesting tonight, rather than carry it forward, also include a decision that if you're going to approve the relief requested, since they need the extinguishment to effectuate their ability to go forward for a building permit, I would recommend that you include that in your motion.
Okay, so can you give me the phraseology, because I'm losing you on this?
Sure. So the last, and I'll just do the last
Yeah,
one.
the third one.
The last one is, it's a motion to authorize the rescission or extinguishment of the covenant that is the January 25th, 2001 covenant that has been recorded with the Suffolk County Clerk's Office, and authorize the chair to sign any document provided by the applicant to provide for such formal extinguishment upon approval of that document by the board's counsel.
Okay, so let me make sure. We have to have a motion to approve the applicant to remove the condition of the 1998 covenant, correct?
It was,
I mean, sorry,
appears to have been recorded in 2001.
the 2001 covenant, that's right. And then we have to have a motion to authorize the rescission or extinguishing of the restrictions in the 125-2001 covenant filed with the Suffolk County Clerk's Office, and authorize the chairman of this board to sign. Is that
To
correct?
sign the extinguishment document, correct.
Right, all right.
I would also put, and any other real property documents that are required to be filed with the clerk's office to effectuate that filing.
I am not going to be able to write all that
That's
down.
right, I got it.
So what do you want, how
No,
can
you
we?
got it. No,
Let me ask you this, how can we vote on this tonight?
Why don't you, if I may, why don't you
Yeah.
state the resolution, which I've done as a municipal lawyer,
Mhm.
and have him vote on it, because he's going to do it properly.
That-
So, do you want, let's,
Can you phrase the motion that we can then vote on?
either way, what's going to happen is we're going to draft a decision with the findings for the June meeting. So
maybe
you're not going to be able to do
June.
anything until after June 26th.
I understand, but I'd
So-
like to vote.
Okay, all right. So the first two parts of the resolution, the motion to approve and the lead agency status, you understand that, correct?
Correct.
All right,
yes.
so the only other thing that you need to incorporate is that the board moves to grant the extinguishment or rescission of the declaration of covenants and restrictions that was recorded with the county clerk's office in 2001 and dated January 25th, 2001, and authorized the chair to execute such document
Mhm.
and any other documents that are necessary to be filed with the county clerk's office to
Yep.
provide for the filing of the extinguishment.
Can we vote on that third motion right now as phrased by you?
Yes,
All right. Do I hear a motion?
and the other two, all three parts,
I mean,
correct?
sorry, yes, excuse me.
Yep.
Do I have? So first of all, we have to close the hearing. Actually, no.
Yeah, you already did that.
Oh, sorry. So, do I have to have a motion? I don't have to motion.
Just a motion to do what he said.
All those in,
Go with that.
all those in favor of
What he
doing
said.
what Brian just put into the record indicate by aye.
Aye.
Aye. All those opposed? It is so moved.
All right, so it was
Yeah.
seconded.
All of it, and the family's very thankful. Thank you very much.
Sorry about the complexity at the end,
Thank you.
but he was saying a lot of things and we couldn't write them all down. Thank you very
Hear
much.
that, Brian? You did it beautifully.
That's only one vote, doesn't count unless I need three.
All right.
I need three of them to say that.
Have a good evening, everyone.
Go have a celebration dinner
All right.
and a drink.
Thank you all.
Thank you. Oceanside Equities is the next case. I would just want to note for the record that the applicant has asked this application be withdrawn without prejudice, so we're noting that for the record, and we can move on. The next case is 3203 Diamond Communications. This is the cell tower proposed for 25 Windmill Lane. It's case number 3203. I'd like to note that they have requested that this matter be adjourned to July 17th of this year. Do I have a motion to approve the request for adjournment?
Sure, motion.
Second? All those in favor? Aye. And it is adjourned to July 17th, 2025, as requested.
Are we investigating whether there are any alternative communication, like SpaceX or satellites?
There's some documentation provided that are arguing against that.
This is the only way.
That is a way.
It's up for debate.
It's up for
They're
debate. We can talk
arguing
about. Can we
about
talk
that.
about that now? We can talk about this.
It's being adjourned, so you
Yeah.
shouldn't be talking about any.
When we
any
hear the
substantive
case
portion of the
next-
We should,
application.
okay.
Yeah, when we hear the case next time,
We should,
Yeah.
we will talk about that
About that,
because
okay.
that very question is in the materials.
Okay, great.
Yeah,
So
it's
you'll see that unfolding,
Okay.
and we will all talk about it with council present and with the Diamond folks present, I'm sure.
Yeah.
Okay. All right. And I would also note for the record, you'll also see in the most recent documents filed, which we will talk about when it is coming back up off adjournment, that there is at least one person who now has objected and filed articles and different things. So take a look at it. All of this is now in the record, in the submission rather, and we can talk about it on the record.
Okay.
Okay?
Great.
Very straightforward. All right, so now we're going to be moving on to the new cases. And the first one is case number 3200, Emmanuel Santomoro, 229 Potato Field Lane. Is anyone here to discuss that case?
Yep. They're coming in.
Oh, great, okay.
Is this screen not working?
Yeah, apparently not. So come on over.
Slide over.
Change my angle a little bit.
Yeah.
Good evening, everyone. I'm not sure if the video is working yet. Doesn't look like it.
All right.
Can you hear me okay?
Yes.
We can hear you just fine, not to worry.
Perfect. Thank you. Laura Tuman on behalf of the owner of the premises.
All right, well, Laura?
I'm sorry about the video.
It is
Oh, my
awkward, but we're all neighbors and we'll get through it.
Absolutely. And my apologies, I couldn't be there. This is a Tuesday. Childcare is a little difficult on Tuesdays. Thursdays, I would have been there, so my apologies.
No, that's all right. So why don't you share with us your comments and thoughts about this case?
Absolutely. So the application that's before you is for what we feel is a very modest, tasteful, reserved application for a small 6-foot by 45-foot, 270 square foot covered porch on the front of their home. The setback is 40 feet, so we're asking for 5.9 feet of relief for a setback of 34.1 feet. A covered porch is basically a pretty common amenity that many homes have, especially in that neighborhood. This house, if you look at the photos that were submitted with the application, is very flat. There's really, the front facade has no architectural features. This would add what we believe is an aesthetically and architecturally pleasing feature to the house. There is no front porch over the front porch or the windows that protect the house from any sun, rain, weather. It's south facing, so sun beats down on that doorstep and rain on the doorstep and the windows on the front facade to the left and to the right of the property. So this is, we believe, a very modest ask. There's no impact to the environment, to the neighborhood, and we believe there was also a letter of support that was perhaps submitted to the board by a neighbor as well. So that is a nice thing for you. So I'm happy to take any questions if you have.
Are there any questions from members of the board?
No, pretty straightforward.
I don't really have a question. I just want to confirm something.
Absolutely.
I believe you submitted with your materials a decision that was before the board back in November 29.
2018. Yep, 2018.
Yeah, where this very request was approved, but for a 65-foot wide porch as opposed to 45, but essentially a front porch was approved previously, is that right?
Correct, yes. And
Right.
before the owners could, construct, the decision expired.
Okay, no problem. I just want to confirm that I wasn't missing something. Great. We don't have any other questions, so I'd like to suggest that we move on forward now to let the board deliberate and discuss this. And in doing so, I want to share something that Brian enlightened me with just before this meeting. And Brian, you want to share the comment about the prior decision and its effect on this decision?
Yep. Since there has been a prior decision for a similar structure in the front, essentially the board has to be governed by that decision, and if there's no change in circumstances, you are limited in what you can do here, which would be to decide in the same way that it was decided several years ago. So if there's been a change in circumstances of some type, whether that's whatever facts that may be, the neighborhood conditions, the conditions on this property, the house on this property, the zoning code changes, any of that, that can support a different decision. But if there aren't any, then your decision should be consistent with the one that was made several years ago.
Okay. So with that in mind, I'd love to ask you, Laura, had there been any change in circumstances in the neighborhood that, along the lines of what Brian was just describing?
No, there have not been.
Okay. So let's go back into board deliberation. I just want to share that precedent with you, if you will.
Was the last time you submitted a request, was the patio bigger than this one or smaller than this one?
I believe the initial request came in 2018 for a 6-foot by 59-foot.
There you go. Yeah, that's right here, 59, and this is now 45. So
Okay,
it's
so this is
just a little
smaller.
bit smaller. Yeah.
Yeah.
So I'll kick it off. I think this is a great improvement.
Yeah, I do
I think it
too.
enhances the look of the house.
Yeah,
And so I'd be very happy to
definitely.
be bound by the prior decision because I think it was the right decision.
Right.
Yeah.
What are
I
your
agree.
thoughts?
Yeah.
It's
Yeah.
not, and it's smaller, quite frankly. I mean,
Right,
it's still
smaller.
going to make the same impact, and it's a little
Right.
bit smaller. So
Yeah.
I don't-
All right. Are we prepared to vote to close this hearing? First, I have to ask for other comments, but close the hearing and go ahead and vote on this matter since it seems straightforward? Okay. Laura, thank you for your comments. Is there anyone here who would like to offer any comments themselves regarding the 229 Potato Field Lane application? Is there anyone on Zoom that wants to come in to also offer any comments on the application? All right. No comments being offered and deliberations have occurred. Do I hear a motion to close this hearing?
Motion to close the hearing.
So I hear a second?
Yes.
All right, then the hearing is closed. All those in favor of approving this application? Aye.
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 And all those opposed? No. All right, it's unanimous 3-0. Laura, it's been approved, and we appreciate your submission and your time.
Thank you so much, guys. Have a good evening.
Have a good one. All right. Look at this, sorry. Okay, the next thing on the actual agenda is a working session, but I'm going to suggest that we move that to the end so that we continue with the actual cases involving individuals, and we can talk amongst ourselves later on the administrative matters.
Okay.
So with that, I would move to deliberations, written decisions. And the first one is 30 County Road 39A, case number 3180, which would extend the split zone lot and so on, which is all described amply in the agenda. Brian has submitted a proposed decision. Any comments or questions on that decision? All right. This hearing was closed, so we can actually vote on it. Are we prepared to have a vote on this at this time? Or should we do an indication for further discussions with the larger board at the next meeting? Any feelings or thoughts? So, well, let's discuss this. Let's discuss the opinion a little bit then first.
Sure.
I think that I would be inclined to approve it because I think they've made the accommodations they've asked for. Unfortunately, their changes were already made and they came in after the fact, but having done that, they've made the adjustments they can make and I think they've met our previous requests, so I would be inclined to go ahead and approve it, but I don't know how you all feel.
No, I feel the same way.
You feel the same way?
Yep.
All right. Do I hear, a motion has already been, we've already closed this particular hearing, so can we go to a vote? All those in favor of
So you need to do it by motion. So you need a motion to approve the decision as drafted.
Oh, thank you. Do I hear a motion to approve the decision as drafted? Aye.
Motion.
All those in favor?
Aye.
It is passed. Thank you.
Great.
Motion is passed. All right. So now we'll go to the next one, which is 36 Windmill Lane. And that is also popularly known as Shippies. That is case number 3191. This hearing was closed on April 24. Let's talk about it a few minutes as we deliberate. Anyone have any comments on the proposed opinion as submitted and circulated by Brian, or on the matter?
So I came into this after it's been closed. So I just did a deep dive and kind of just to get a better understanding of what they're asking for and what the concessions are and so on. And I also appreciate, I see what they've done there. I've actually gone to the location just to understand what they're intending to do and so on. I think the concessions here are reasonable, and I just feel that it's you make an investment the way they have, and what they've done I feel to that side of the village is incredibly important, and they're making prudent decisions to even further enhance that street. And I think you want to give them that opportunity to go forward. That's just how I feel about it. I just think that it's reasonable.
Linda?
I think they've, as you pointed out, they've done head over heels to really do a fantastic job in improving the whole end of that street.
Yeah.
Wish everybody would.
If just even the area, I understand that the number of parking spots are not exactly the number that we were hoping to achieve. I still think that improvement will change it there.
I do too.
And they're willing to pay for 10 additional
That's
spots
right.
in the public
Correct.
lot.
Correct.
So rather than build 4 more on their lot, they're giving us 10 more, and they're paying into the parking fund.
Yes.
So I
Yes.
think they're really trying to.
Yes,
to
they want to
reach
be want to
people.
be there for the long haul, and it has a very authentic local feeling. I really commend them for taking on this task. That the state of that restaurant beforehand was in dire need of something like this,
Yeah.
and
Yeah.
I think it's impressive.
I couldn't agree more, and it's completely consistent with the planning document for the village in that area,
Completely.
so, okay. So, are we prepared to vote on the decision that Brian prepared, which would approve the application? Brian?
Just to note, in that regard, I circulated, there were a couple of comments with respect to the decision. I circulated a revised version about an hour before the meeting.
Yes.
And just want to point out what those changes, the substantive changes are. Much of it was just textual, but there were some substantive changes. One was a new condition that the special exception approval expires on January 1st, 2026, and may be reapplied for annually, which is consistent with how the code reads. 2, I added a condition prohibiting outdoor music or sound amplified from the interior of the building. And 3, I modified the condition regarding seating locations to assure that the seating locations shall be in accord with the plans submitted with the application. Other than that, the decision is essentially exactly, with some minor textual changes, exactly as it was presented to you previously when I distributed it before.
Right. I'm just fine with that. Are we prepared to vote on whether we would like to approve the proposed decision? I am.
I think so.
All those in favor of
Aye.
approving the decision? Aye?
Aye.
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 All those against, say nay.
Yeah.
And it's unanimous, 3 people. All right, so that's, Shippey's matter has been approved. All right, moving on. 85 Down East, which is a wetlands permit matter, which Lisa has kindly provided to us. And Lisa, we simply have to approve this if we wish to do so.
Correct.
Brian, do I need to make a motion to approve her
Yes.
draft?
If I
Correct.
can just point out, I think there were seeker decisions, which I don't believe were made at the last meeting,
Oh.
because technically while under state law, this would be a type 2 action, the village law does make wetland special permits type 1 actions, so the full environmental assessment form has been submitted, and the parts 2 and 3 have been completed, and a reasoned negative determination was made. So you'll just need to take action first on the seeker decision, and then you can vote on the application.
Are you saying that we have to vote to approve Part 2, identification of potential project impact?
You'd have to vote to recognize this as a type 1 action per village code, and that the Part 2 and 3 were completed, and the board is adopting a negative declaration.
Right, so just to modify that slightly, so the board will declare itself lead agency, there's no coordinated review required, and you'll determine that there's no likelihood of a significant environmental impact, as demonstrated in the EAF that was provided, and authorize the chair to execute the EAF to provide exactly what we just said, which is that there is no potential for a significant adverse environmental impact.
All right. Do I have a motion to vote on that?
Yes.
Yes,
Second?
yes.
All those in favor of what Brian has now postulated? Aye.
Aye.
Anyone opposed? No one is opposed. It passes as 3-1. Now, do we now need to vote on the wetlands permit that you have drafted?
Yes.
All right. Do we need to have a motion to vote on it? All right, do I have a motion to approve the 85 Down East Wetland Special Permit that Lisa has drafted and provided to us prior to this meeting?
I motion to.
And second?
Yes.
All those in favor of approving the drafted wetland special permit? Aye.
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 Passes 3-0. All right, so 85 Down East has been approved. Oh, all right, we can give it to the folks here. God bless you.
That explains the turn-in.
They'll be back.
They'll be back. We can give it to the
I
village.
won't be back. I'm going home to watch the Yankee game.
All right. Well, we're going to go on to our last case of the evening, and that is 75 Hetty Creek Lane, case number 3201. This is a request for relief for decreasing the front yard for a first and second floor addition, and thank you. A wetland special permit has been prepared by Lisa and circulated to us, and I believe, yeah, it goes through exactly what we just went through on the prior application. So Brian, could you please postulate
I'll just say, you'll make a secret motion, the exact secret motion you made on the previous application.
Same.
All right. Is anyone so moved?
I moved.
Second?
Aye.
Aye. All right. All those, and also we have to vote on the wetland special permit as well. All those in favor of approving the wetland special permit? Aye.
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 All those opposed? And the wetlands permit is approved as well.
All right.
That should resolve and approve 75 Hetty Creek Lane. Lisa and Brian, do we agree?
Yes.
All right.
Oh, wait, they voted on the variances too?
Were there variants? I don't have it on.
So Hetty Creek Lane had two things for it. The only part I was helping with was the
Septic.
special wetlands permit. There was also
Decrease-
variances
yeah.
related
Decrease the
to
front yard.
the expansion of the second floor addition, I believe. Decrease of the minimum front yard setback from 60 foot to 52.5 foot on the first and second floor.
Oh, right.
So it was a pretty, since I was here for the presentation of that application, it was I think that there was also some evidence submitted that at the last meeting that they had put there was one concern by the neighbor about the visual impact. and they planted some additional shrubbery to screen it, and they showed that at the last meeting.
Oh, that's right.
And the neighbor withdrew their concern about it.
That's right, they did.
But I don't know if a decision was drafted for this yet? No?
No,
Okay.
no.
No.
We're going to have to put the variance portion of this over to the next meeting where a decision can be drafted that we can vote on.
Okay.
But at least we've resolved the environmental issues.
Yes, the wetlands.
All right, thank you for that.
This part.
All right, Brian?
I will take care of that.
All right. So that takes care of the cases. We just have two straightforward matters for administratively, if you will. If I could keep you all going for just a moment or two more. First of all, we're trying to put together a calendar. As we discussed at length previously, we decided we are going to go to meet every Thursday on the first week and the third week of each month.
The first week and the
Third week, first and third Thursday of each month. Those dates were posited to us because other boards and the trustees and so on met on other dates and so on. So that ended up being our available time slot. So we have the first and third Thursday, 6 p.m. for the rest of the year and going forward. That's fine. I've asked everyone to give me their dates of availability or lack of availability because I'm going to put together an annual calendar and I'm going to send it to you all so we can see if we have nobody on September 15th.
Right.
That kind of thing. I've already gotten it from Tom and from Joyce. If you could just take a few minutes and, let me know if you, I'm going skiing this month or something like that. Let me know. And we can change.
Okay.
Things happen, but at least we'll have a general calendar we can all go by.
It used to be once a month.
That's true. We do
Amen.
need to know. Excuse me?
It used to be once a month, and we feel that the caseload is going to require two times a month?
From what we were told in our earlier meetings and discussions, it used to be twice a month, and then
Oh.
COVID hit. So they reduced it to once a month, and it was remote.
Ah.
And now people have so many applications, they wanted us to go back to twice a month.
I see.
Although
So
Ron Bennett.
He was saying for the last 50 years it was once a month,
Oh,
John. That's what John Bennett was
I know, but
saying.
they said earlier, Alex said it used to be, I believe,
Yeah,
whatever.
I was there for that when
Yeah.
he was talking about
Yeah,
it.
he was saying
I-
it twice.
I will
Just
say-
an observation is that a lot of them end up being canceled, so because of inavailability, so I think having the two
Having the
dates you
two.
consider,
Yeah.
usually you end up with one a month, which is at least. Which
Oh, I
think-
see.
And I think with the pace with which you are moving forward with applications as compared to the pace that was previous to this, this board in its current constitution, you're going through things a lot more quickly. So there may not be a need for a second meeting every month. It may be overkill, but you have to
But
make
I
that
think
decision.
there's a couple things that are open that are significant.
There might be, right,
I mean,
exactly. You
from
had
what
the
we're
cell
seeing,
tower and some
there's
other things.
Things that I think are heavier than
Right.
what we've just received, and a lot of this was we already had the information, and we were
Right.
ready to go.
So what you could do is have it done, have meetings once a month, and then when you do have situations like that, always work out a second date.
Or we keep, like what Lisa was saying, you keep them twice a month, and if you don't have enough, you can always just not have that second meeting.
If you want to do it that way, that just clogs up everyone's schedule, though.
Well, that's true. All right, what do we want to do, guys? 6 1, half dozen the
How
other.
about the other way around? How about have it once a month, and if the load gets...
That's what he's saying. You add on another one.
Add on rather than subtract.
Well,
Because
that's-
it's very hard to travel.
How long do you have to give notice? 30? Is it 30 days?
No, I'm not sure what the village code requires, but it's nowhere near 30 days. It's usually, it may be 10, publication, it could be 5 days or 10 days. It's probably not longer than that. And notice to the neighbors, I believe, is probably not more than 10 days.
I can tell you it has been brutal getting a quorum for these meetings every 2 weeks. So I can attest to that. Everyone's very busy, and our residents as well. Do you want to try it, just doing it once a month and see how it goes?
Okay.
All
I
right.
would prefer that.
Well, since we're here and Joyce and Tom aren't,
Yeah,
would
we
you like to
vote.
pick the first or the third Thursday of the month? Anyone have any
I'd say
preferences?
the first, because then we can always add on
The
in the
third.
month if we have an overload or
Yeah, knowing that the room is available.
knowing
to-
that.
Can I just mention, though, that you currently have items deferred?
Yeah, we're
that-
not going to change, you're not going to change
their
those.
Those you
upcoming-
can't
Right,
change those.
exactly.
Those ones
It's
are
just
said
a
it's going
forward-looking.
beyond that.
Yep.
Oh, that's true.
That's true. They're hanging somewhere.
Yeah, if some were put over to
To
the
a set date.
third Thursday or something, or, yeah, okay.
I-
We'll
So,
have-
yeah, so you'll leave June 26th, you will leave July 17th, and you could start the first Thursday going forward after that, because I don't think anything has been put off to August or after.
So it'll be, no,
No.
so it'll be August. In August, we start once a month on the first Thursday. Until then, we will go with the 2 for
Right.
July.
And I don't know, do you want to meet on July 3rd?
Oh, that was my other question. July 3rd. I'm going to be here, to be honest with you, so I can come on
Yeah,
over.
me too.
You're going to be here, so,
We're all gonna, I mean, that's a big,
so you want to just keep the schedule? I don't know that we'll have any cases, because I think maybe the residents don't want to be submitting things for July 3rd, but I'm willing to keep it on the
Yeah,
calendar.
let's keep it on the calendar.
All right, so we'll keep going with it. All right, so we'll keep the dates to which we have adjourned cases, but then after that, which appears to be August, we will go to the first Thursday of each month. All right, that's the calendaring issue. The second issue, I just want to give you a heads up. We have received an opinion from the appellate division. It's called in the matter of Hampton Village LLC versus the zoning board. Apparently what happened was an applicant sought a special use permit and certain variances. They own property in the business district where the zoning is, it's the business district, and residential use requires a special application, special exception. They came in for a special exception. They wanted to build a house, and so they asked for the special exception. In addition to the special exception, they wanted certain variances, certain area variances. The zoning board heard it and in 2022 said, no, we do not think under the various tests that you should be able to build this house, and they rejected it.
Okay.
The individuals involved, the residents, appealed to the court system, and it's gone up on appeal twice. And the court system came down on June 4th, 2025, just days ago, and said, no, you should have approved it. There's not enough evidence, if you will, to have not approved it. So we've been ordered, if you will, to approve it. Now, we need to read this opinion, decide what we need to do, and how we need to address it, as Brian points out. But I wanted to make you aware of the opinion, and we'll see what happens
so
going
if we're
forward.
ordered to vote,
Where is it?
we're ordered to vote, just to approve this, we have to overturn our original, whatever this original decision.
Mhm.
So what is there, what do we have to deliberate over? What are we, what's
Just to look at the decision to see if it allows you to impose conditions that are appropriate, or just approve it as is.
Got it.
I certainly haven't, I know it's a short decision, but I have not read it to understand, nor have I read the underlying determinations.
Okay, so we're kind of, I parsed through it, but, that's because I had time. So you can take a look at it. It's in the materials.
Yeah, I saw it.
And Brian will be looking at it as counsel. It is a legal opinion, and we'll see what we need to be doing, okay? So Brian, my other question for you in terms of looking at this is, are there any other opinions? There was a cover email from the village attorney about another case, and I wasn't quite sure what to do with it. So we can maybe talk about that, but I'm a little confused about what to do with another case, okay?
Yeah, I think this is the only one that I've seen, though, so
Okay.
I'll see what else is out there.
Okay, all right. So that's the case. We'll see where it goes. Take a look at it. It's in your materials. It's very
So
interesting.
find something like this, but it still does, I can't find where it actually is on Hampton Road.
Oh, I don't know that. I only have the opinion. Sorry.
Oh,
And it's
you only
not
have the
clarified in the opinion. No.
Okay.
Okay, so that's the opinion. The second thing, only other thing we wanted to talk about today, I just want to make you aware, because we have cases coming up. We all know that pickleball is out there. It's the big booming sport, and everyone talks about the noise of pickleball courts. A lot of tennis courts are out there, and some tennis courts are being converted into pickleball courts. The trustees did a great job. They passed a law last year about this. They actually addressed the issue. And so I can share it with you. I actually put it in a link, but I can share it with you. But basically, they've added on references to pickleball court and paddleball court where we have code references to tennis courts. But they deviate. But nevertheless, they say, number one, the pickleball and paddleball courts are now deemed to be accessory structures just like the tennis courts. And they can be in rear and side yards, just like the tennis courts. But where the code currently says a tennis court shall not be installed nearer than 20 feet to a lot line, a new pickleball or paddleball court has to be 30 feet from any lot line. They're giving it a little more distance, probably because of the noise, right?
Mm-hmm.
And when you convert an existing tennis court, they say it is permitted, but once again, it can only be converted if the existing court is a minimum of 30 feet from all the property lines.
Got it.
The theme that we have to be aware of educationally
30 feet.
is a 30-foot trigger, exactly. anything that's already out there is if you have a pickleball court, it's pre-existing non-conforming. No lights allowed, and again, that's the same for tennis courts, nothing new there. It says the fencing or barrier around a tennis court cannot exceed 8 feet at the ends, and so on and so forth. It says no permit for the construction of a pickleball court or paddleball court, so they're singling out pickleball and paddleball here, can be issued until the site and landscape plan, therefore, has been approved by the planning board and the building inspector. Doesn't involve us, but just so you're aware.
Right.
And if you were to read the legislative history, the comments by the trustees, they wanted to make sure that they could put up things to block the noise, the screening to block noise. And in fact, it says it here, and the required landscaping and sound attenuation mechanisms. So that's what they're looking to do. It further says the building inspector, in consultation with the planning board, shall adopt and publish minimum sound attenuation, landscape, and screening specifications, including the sinking of the subject courts, et cetera, to control storm runoff. So that's it. So basically, paddleball and pickleball now have been inculcated into our code, 30-foot setbacks, and lots of stuff about sound attenuation.
What's the sinking part of it? Do you have to
Apparently,
sink it a couple of feet?
Apparently, tennis courts are sunk 4 feet to prevent runoff if they're on the surface. There's a lot of runoff. That's my informal conversations with Alex. I said, why? And that was his answer. So we can do some research, but yes, that's why you see tennis
Where
courts
they
sunk a
want to
little
put
bit.
it is right next to the pond. They couldn't.
Well, that's Meadowlands, the Meadowlands Club case, and we can talk about that when
Okay.
it comes up.
So this is
That's
another,
different. This is just
Just
this
code.
is the raw language in the code.
right, I got it, okay.
Now,
So
it also
padel and pickleball are now in the
in the code.
language.
And by the way, it also says in here, a lot shall not contain more than one playing court. That
Oh.
playing court can be used for multiple sports. You can play basketball on your tennis court, but it can only be one. Now, Meadow Club is a different situation because they have variances granted and so on. We'll talk about them separately when they're here, and it's an open public meeting law kind of conversation. But this is for all those residences out there that have a tennis court, that come in, that want to convert their tennis court to a pickleball court. Can they put 2 pickleball courts on it? Apparently, I don't want to prejudge anyone, but this says more than one playing court.
Right.
So we'll have to look at this code when the applications come in. is
Yeah,
my
I was
point.
fascinated. Pickleball. I played. I'm a big fan of all racket sports, but if you replace with the tennis courts that are out there with pickle, I really am fascinated to learn how they're going to handle the sound. If you have in every court today, if you go on Meadow Lane, and everyone has a tennis court, if you put in replace a pickle, Meadow Lane will sound differently. So I just want to know what are they using? What's the landscape buffering?
Attenuation.
What is it?
Yeah.
How are they wrapping the courts? First of all, the courts are all hard. It's not a hard true. They're not grass. They're not clay. It has to be asphalt. So there's a pinging sound, and then just by hitting padel and or pickleball, the volume of the hits are 5x. And
The
it's just
the speed of the game.
all of it is just a very
It's
different thing,
amplified.
and it's amplified. The sound is amplified. So I just want to know what that is. What are they going to do to protect the sound?
Yeah.
And that goes with the other case that we'll talk about.
I would say
next
it's
time.
all going to come up.
It's all that has to come up.
Yeah. And that's why I want to prepare you that there's some guidance on this, and the preamble to the code, which can be looked at when deciding things, they specifically say this is because of the noise. So it's a well-known thing. And in some of the cases that we're about to hear, there has already been an objection filed, and the objection is 1 inch thick and is replete with all the studies of noise and all that good stuff. So yes, this is no surprise. It's going to come up. We're going to have to handle it. Be aware there's a code section you can fall back on a little bit for some guidance, and then we'll take it from there. Brian, any other comments on that?
No, nothing.
No?
No, I'm not offering my opinion on pickleball.
Pickleball. All right, well, that's it.
Wow, that was fast.
All right,
That's great.
comments, that's it? Everything, Lisa, thank you. Brian, thank you so much. Thank you.
So, Brian, you happen to have